Hi, Attorney Nydia Menendez here. Today's famous estate will be Aretha Franklin. Aretha Franklin was known as the Queen of Soul. I grew up listening to her tunes, which were not just harmonically excellent, but the lyrics were inspiring, uplifting, and absolutely empowering. Remember, Aretha hit big in the post-civil rights era, so in my eyes, she was iconic in so many different levels. But as will be the case for all of us, Aretha passed away in March of 2018. She was only 76 years young. When she died, her family believed that she did not have a will or any other form of estate planning for that matter. What that meant is that under Michigan law, her estate would be divided equally among her four sons. And with that understanding, the sons approved the appointment of their beloved cousin Sabrina as the personal representative for the estate. But since then, three handwritten wills have been found, including one that was found a year after Aretha's death, stuffed between the sofa cushions. Who's cleaning that house? Turns out that Aretha may not have died intestate after all. And if there was a will, that would change everything. In other words, Aretha's estate would not have to be divided as dictated by the state of Michigan, because now, if there was a will, Aretha would be telling the world what she wanted to do with her stuff, who she wanted to give it to, and under Michigan law, a handwritten will could be valid even without witnesses as long as it is signed, dated, and in the handwriting of the deceased. Now, Aretha's estate is valued to be worth approximately $80 million. Clearly, that has to be enough for each of her four children and a few other people that Aretha may have included in the handwritten wills. According to Michigan law, the family could bypass questions of the validity of the wills if all heirs can come to an agreement. But it appears that a solution will not be a simple thing. Lawyers connected to the estate say that they do not expect an agreement among Aretha's heirs. And just like that, litigation continues. A key point in the litigation revolves around who will be the personal representative. It is now clear that the once beloved cousin Sabrina is no longer as loved. According to one of my colleagues in Michigan, there was a hearing in August 2019. Now that's more than a year after Aretha's passing. In that hearing, there were 9 attorneys and the hearing lasted for more than 5 hours. How could there be 9 attorneys? She only had 4 sons. Well, my guess is that Aretha may have wanted to include other people to be beneficiaries of her wealth. The court has appointed independent handwriting experts to review each of the documents to see if it is a will. Let's see what that reveals. And let's see if any of the purported wills left by Aretha will receive any RESPECT. So the moral of this estate, oh my, there are so many, but I'm going to settle for just one. Plan. Plan to make sure you leave your affairs in order. Plan to protect what you worked so hard to achieve. Here's my thinking. 9 attorneys, a 5-hour hearing. The billable hours on that had to be in the thousands and thousands. And that's how you spell waste. Plan to make sure peace of mind is part of the legacy you leave for your loved ones. Fighting and bickering over who gets what is not what you would want. So make sure you have the final say. Plan.
If you like this video, please like and share. And if you want more videos about estate planning, subscribe and ring the bell to be notified when we release the next video. Thank you for watching and see you soon.